So good morning. We're here for our December policy meeting. We had a special policy meeting yesterday from 9 to 4, and I think we're going to carry over some of that discussions. There was some discussion informally last night, which I'm sure we'll get caught up on. So I'll turn it over to the executive director.
Thank you, Judge, and good morning, and thanks to all the members again for a long day yesterday. And then, although our dinner meeting was published and it was a public meeting, we did have an informal discussion, just sort of where we are and where we go with the efforts around the 8th edition guidelines, the planning that we've been doing and how to engage the public in that. So we can talk more about that, if not during this policy meeting, during the quarterly meeting coming up. So we'll return to that then. This morning, we'd like to start off with a couple of more timely issues. Some of you may be aware, I think we provided it in the meeting materials, that the House of Representatives recently passed a resolution. I think there was a typo in the material, so I apologize for that, but a resolution was passed to require the commission to study or to conduct an investigation or study an investigation, prosecution, and sentencing of the violations of Pennsylvania's Uniform Firearms Act. And this isn't in a vacuum, of course. There's been real concerns about firearm use and victimization and deaths during the last couple of years. And there's other legislation that's in the General Assembly moving through committees and in the House and Senate. 3 bills come to mind that I'm aware of that we've received inquiries about in terms of impact and so forth. House Bill 1564 would expand violations of Section 6105 to include inchoates. From what I understand, there is some difference of opinion about whether inchoates apply under 6105, and so this legislation, I think, is more for clarification of that to clearly include inchoates in the violation. House Bill 1587 is a pretty comprehensive bill. It looks both at pretrial detention issues and also at sentencing, and it would provide for a number of mandatory minimum sentences, especially related to repeat offending and to use of a firearm with other offenses like crimes of violence, etc. And then House Bill 1590, which is sponsored by Representative Stevens, would take a different path and would look at having presumptive guidelines for those types of firearms related offenses, those violent offenses with firearms. And so this study that we've been asked to do, I think, is really helpful in informing the process, the legislative process, in trying to understand what's happening as cases move through the system, and any kind of insights that we can provide to the public and to policymakers, to the General Assembly, about takeaways from those processes, and that might inform these bills and other legislation. So really happy this morning to ask Dr. Matt Kleiman and Dr. Miranda Galvin to talk about some work they've been doing to prepare for this and to help move us forward. We've clearly had discussions about this resolution as it was being drafted and developed with the Judiciary Committee, with others, clearly with the sponsor, and so it gave us sort of a heads up and ability to start to pull together, develop a process and pull together data so that we could do a good job on this study. But it's a big task. So we thought during the policy meeting today, because this is such an important topic, we'd spend some time just talking about that process, talking about what we plan to do, what we've done so far, and there's clearly some limitations. So trying to make sure that we figure out how to make the most of this opportunity to study this topic. So with that, I'm going to turn it over to Matt, and he can get us started.
Madam Chair, I do have a question.
Go ahead. I'm sorry. On the wrong computer, so I don't know where my buttons are.
That's okay.
Go ahead.
Could the executive director address whether or not any of this legislation or resolutions is directed toward any specific judicial district?
Thanks, Judge. No, it's not. In fact, it's written more broadly. It's about the Commonwealth as a whole. Now, clearly, there, across the Commonwealth, there's reports in Philly, but also, Pittsburgh. Throughout the Commonwealth, there's just been a concern about an increase in gun violence, and so the resolution as written is a broad resolution. The study that we're asked to do is Commonwealth wide, not for specific jurisdictions.
Thank you.
Thank you, Judge.
Can I chime in on that?
Please.
Yeah, it is Commonwealth wide, but the goal of the legislation was to take a look sort of comparatively at different counties across the Commonwealth, because there are certain counties that are experiencing higher rates of gun violence than others. And we'd like to really just gain a better understanding of the policies that are being used in each of those counties to help inform us as a legislature as to what we might be able to do to stem the tide with some of this gun violence that's occurring where we're seeing heightened activity. So the idea really was to dig in statewide so that we could understand any unique traits that might be occurring, or practices or procedures that might be occurring within certain jurisdictions to help us better understand what we might be able to do as a legislature to help address it.
Is it possible that the committee members can be sent a copy of the resolutions or the proposed legislation so that we can get a head start on it and look at it?
Sure.
Judge, we included in the meeting materials, but it's buried in there. So what I'll do is just send out an email to you so that you have that. If there's any other members that want us an email with the link, I'll provide that as well. But I'll get that out to you right now, Judge.
Thank you very much.
Can somebody just also maybe just give us a reference for where in the current materials we can access it?
Sure, it's in the supplemental packet, and it's under the policy section. So it's a copy of the resolution. I think it's a 3-page resolution. But again, I will I'll make sure we put that out there, and I'll send a copy to the judge. Thank you. So over to Matt.
We have another question here from Representative Krajewski.
It was just a comment / clarification. Just in reading through the text, it is a statewide study, but the resolution does begin with laying out statistical data in Philadelphia. So I do think that that's important to mention. There isn't any other statistical data for other jurisdictions in the House resolution. So I just wanted to add that clarification.
Okay, well, thank you and good morning, everyone. As Mark mentioned, this project really at the commission level started about 3 or 4 months ago as this resolution was being considered and drafted and refined. And that was really a process for us to begin collecting necessary data and assembling that data to be able to address and answer those questions that are in the House resolution. As noted, this is a comprehensive statewide study where we'll be looking at county classes and making comparison across the county classes and potentially individual jurisdictions. But our data that we're compiling and collecting is from all jurisdictions. And in an effort to assemble this has been a lengthy process to collect this information and put it in a manageable way for us to begin the analysis. But thankfully, with the timing of when it's been passed from when it was introduced, we've made a lot of headway on that processing and compiling of our information, and have already begun working on really the first of the research questions that are laid out in the resolution. So I'm going to turn it over to Dr. Miranda Galvin, and she'll discuss the progress in compiling the information and where we are in the analysis and some of our analysis strategies for answering the different questions that are in the resolution. Dr. Galvin.
Good morning. Thank you to all of the commission members for indulging us as we update you on our process. If you'll just indulge me a brief moment while I set the screen share. All right. Hopefully everyone should be able to see. Can I just get a confirmation?
We're able to
Okay.
see it.
Okay, great. So thank you. As Matt and Mark have introduced, this is going to be discussing the process of the project and the progress we've made on our study that has been mandated or directed by HR 111. And again, as Matt and Mark introduced, we've seen while the resolution may speak specifically to Philadelphia, we know that nationally as well as locally, there's been a significant rise in firearm violence, particularly in the last 2 years. And HR 111 specifically directs the commission to conduct a study broadly considering the processing of firearm violations. What we're going to call VUFA in this analysis. And we kind of think of that as the processing as falling into 3 buckets. And we'll talk about these buckets as we move forward. And that's the prosecution of these offenses. So when they're filed, what happens to them, the sentencing of those offenses, and whether or not individuals who are charged and sentenced for VUFA offenses go on to commit future crimes, particularly of violence or violations of community supervision. And we've been given a directive to complete this by the end of June 2022. And I think we're all very optimistic, given that we've been able to start the process. So I'm going to now briefly give you an overview of how we're seeing the process and the different sources of data that we're going to use to address this. So broadly, please excuse the very oversimplified criminal justice system here. When we're thinking about the universe of VUFA offenses, on one hand, we'd really like to have, the process starts with an arrest. Some of those offenses are going to be null pros. However, many of them will go on to be filed. And we're going to identify dockets that have been filed with VUFA offenses, follow them through to disposition, both in the lower and upper courts. And then we can link those disposed cases to sentence offenses. And along the way, our goal is to also follow the cases and charges that are withdrawn, that deal with dismissals, that time out and have to be refiled later or undergo charge reduction. And if we think about these as kind of the general 4 buckets of the process, we're going to draw data on each of these 4 stages from different sources. And so all arrest data, obviously, we'd like to have from the Pennsylvania State Police, while filing and disposing of dockets containing VUFA offenses is going to be drawn from the Administrative Office of Pennsylvania Courts, AOPC. And then to get information on the sentencing of VUFA offenses, we can look both to the AOPC as well as our own PCS data. Now, briefly to discuss each of these data sources, I do want to start with, unfortunately, a limitation, which is that we would really like to have all arrests for VUFA offenses and start our process there. Unfortunately, the process by which we request data from the Pennsylvania State Police does not allow us to specifically request a bucket of offenses based on statute. And so we're not able to identify, start our process of understanding the movement of VUFA cases through the system with arrest. However, we are in the process of, we have staff working to understand the extent to which our findings might be affected by this omission. And so we have staff who are following up with jurisdictions to find out which jurisdictions use direct file and in which jurisdictions prosecutors screen some or all offenses. And to the extent that we have direct file in a large portion of districts, we can expect that the additional inclusion of arrest data wouldn't necessarily increase the rate of VUFA offenses, and we wouldn't necessarily see that different a picture. So by breaking apart the process for districts with direct file and comparing them to districts with screening, we're going to be able to get a better idea of what the true universe is and hopefully be able to give some bounds on what we're missing by not having those arrest data. Because we don't have that arrest data to start our process, really the story for this project is going to start with filing, and AOPC data are going to be the workhorse for the bulk of this project. So we're going to use AOPC data to get at the filing and the disposed dockets, as well as some information on sentence offenses. And if we think about the AOPC data, it's not, it's a little bit misleading to call it the AOPC data. There are really several related data sets. And so AOPC provides us data from both the lower and the upper courts. And for each of the lower and upper courts, we also have filing and disposition by year. And so if you work that out, we have 2 lower courts, 1 upper court. We have 6 filing and disposition files for each year, and we have 6 years of data. So it's 36 data sets that are ultimately being appended and linked together to give us this overall picture. And because of that, we've already invested quite a bit of staff time into doing that. And that process of appending and linking the cases across the AOPC stages is where most of the staff time has been up to this point on the project. And it's taken us a little over a month to get the data into a point where we feel as though we have a really good system for following those cases across the process.
Miranda, if you're able to change the view, we see all the slides on there right now. Can you go to full view?
Sure. Okay. You know what I'm going to do? It's over here. Still the wrong one?
Yes, wrong. You go to the bottom right. You exit out and go to the bottom right on the PowerPoint.
Yeah, hold on. It is unfortunately presenter mode. Give me a brief moment.
And we're able to put it up on this end. There we go. That's perfect. Thank you.
Sure. Sorry about that. You had to deal with a much more cluttered view than you needed to. So turning back to where I was. So once we've linked the AOPC data, which we've made incredible progress on thus far, we're going to use both AOPC data and our own PCS data to look at the sentencing of VUPA offenses. And so for those of you who are not familiar with our data are drawn from sentences that are reported to us by jurisdictions for offenses that have been sentenced in courts of common pleas. And our data are known both administratively as well as even in academic circles as being very comprehensive and offering a really rich view of criminal sentencing. The unfortunate thing is that we do not have lower court sentences. And so for some of the VUPA offenses, we're going to have the ability to be resolved in lower courts. But most of obviously the F1s and F2s, we will have, they'll be in the common pleas data. But we do know that our data sometimes are not reported as much as we would like. And the commission has been in the process over the past several years of working with counties to improve reporting. And we've seen really some great compliance, but there are some districts that provide a large number of VUPA cases for which the reporting rates are lower. And so for that reason, we need both the PCS and the AOPC data to provide us information about sentencing. So I'm just going to walk you through now our analytic plan based on the specific directives within HR 111. And for at least one of them, we're going to talk about some of the preliminary findings to give you an idea of what VUPA, what these cases are that we're talking about and that we'll be studying moving forward. So the first directive given to the commission is to study all VUPA offenses all cases with a VUPA offense from 2015 to 2020. And every VUFA collectively refers to, I think, close to 30 sections under Chapter 61, which we will all collectively call VUFA. And so to do that, to identify those cases, we're using those AOPC lower court case filings, both the magisterial and municipal district courts. And we are pulling together the 2015 to 2020 filings in those lower courts and identifying all docket numbers in which a VUFA charge was included. And so that becomes our universe of cases. And we're following both at the case and the charge level, but we wanted to have that aggregate of, all cases that contain any VUFA. And as we do that, we're interested in the general frequency of VUFA offenses and VUFA dockets, as well as looking at the grade of the offense, whether or not the offense involved violence, whether the VUFA charge was the primary or the secondary charge in the case of multiple offense dockets, the individual characteristics of people who are charged with VUFA offenses, and whether or not there's any county variation. So I can briefly walk you through what we found here. And from 2015 to 2020, we found just over 51,000 dockets that contained any VUFA offense. And if we look at this by county class, you'll see that obviously first class county makes up the bulk of that, a bulk of those dockets. However, we also see substantial portions in the third class, which generally surround that larger first class county, and substantial portions in second class counties as well, with much less frequent VUFA cases in the other classes. For those of you who are unfamiliar, VUFA does contain the Uniform Firearms Act does contain a specific section that refers to firearm carrying in Philadelphia. And so we wondered whether that offense might be the reason for this large proportion of VUFA dockets being in first class county. And so we did look at that, and you'll see that the picture really doesn't change that much. So this is all VUFA dockets. And then if we take away the dockets that only include 6108, which is that statute, the effective statute, it really doesn't change the picture very much. We actually only see a few hundred cases out of our 51,000 that contain only 6108. So those 51,000 dockets represent just under 2% of all dockets filed from 2015 to 2020. Although we do see some county variation in the frequency of VUFA dockets as a proportion of all dockets. And so in Philadelphia, we see closer to 10% of all dockets contain at least one VUFA charge. In Allegheny, we see only 2%. And then in pretty much the rest of the counties, we see 1.5% or less of all dockets. Particularly as you get into the smaller class counties, the percentage of all dockets containing a VUFA offense drops, well below 1%. Those 51,000 dockets contain nearly 100,000 offenses. And that's generally because VUFA dockets contain multiple offenses, which is not generally true at conviction, but at filing, we see a lot of multiple offense dockets. So in about slightly more than half of all dockets, we see that VUFA is the top charge. So it's 28,000 of our 51,000 dockets. And the remaining being the lesser charge. And when we say the top charge, that specifically refers to 4% of all dockets in which there's only one offense, meaning that the VUFA is automatically the top charge. And then 52% of dockets contain multiple offenses. Multiple offenses and VUFA is the top charge. We are particularly interested in VUFA cases for that are serious crimes, so F1 or F2s. That's slightly more than 40% of all VUFA dockets that we found in this time period. And of those VUFA charges, of those VUFA dockets with a serious F1, F2 designation, 17% were co-charged with a violent offense. And generally, we see the same pattern as with VUFA more broadly, where at charging, we see very few single offense VUFA dockets with an F1, F2, and most of them, 96%, are a multiple offense docket. And if we think about those multiple offense dockets with a serious VUPA charge, about half of those multiple offense dockets with serious VUPA charges, the VUPA charge is the primary, and about half it's a lesser VUPA. Being charged with violence is actually much more common when VUPA is a lesser charge in a multiple charge offense. And that's generally because the crimes of violence that we're looking at that were specified by HR 111 are very serious felonies. And so they're more likely to be the top charge, and VUPA will be the secondary charge. So as I mentioned, VUPA contains a large number of sections, close to 30, I believe, but our violations in the sample are generally found in one of 4 sections, and that's going to be 6105, prohibited persons, 6106, licensing violations, which is the most frequent charge that we see, 6108, which is carrying firearms in Philadelphia, and 6111, which is sale and transfer violations. So to save you that quick math, only 4% of VUPA offenses are something other than those 4 violations. And so to look at each of those a little bit more in depth, we see that for 6105, which is the second most common VUPA charge in our sample, most of these charges are going to be what we're going to call serious F1 and F2 violations, generally F2, but we also see a pretty sizable portion of F1s. Slightly more than 10% M1s, and then a small portion that are other or unclassified. 6106, on the contrary, which is again the most populous offense that we see, is actually much less serious. We're dealing with mostly M1s here, a small proportion, less than 10% F3s, and again, a small portion that are either other or unclassified. Carrying firearms in the streets of Philadelphia is almost universally an M1 offense, with a small portion being unclassified. And with 6111, we're not dealing generally with misdemeanors, but we are dealing with F3 offenses. And so what that means is when we look at that sample of quote unquote serious VUPA cases with an F1 and an F2, most of those are going to be 6105, right? 6106, 6108, and 6111 are not going to be included in those samples. So 6105 is really where we're going to see those serious VUPA charges and see the bulk of that group. And in general, VUPA offenses, as we discussed, 40% of dockets have a serious charge. F3s are really the modal charge for VUPA offenses, with the second most common being M1s, and then a very small number of M2s and M3s. Just give you a brief overview of the individuals who are charged with VUPA offenses. Our sample is predominantly male, 93%. They have a mean age of 31. It's slightly skewed. We have more people on the younger end than the older end. So some older individuals are pulling the average. And when we look at serious VUPA offenses, they're slightly younger. Their average is closer to 28, but it's a very small substantive difference. We're dealing with people in their late 20s, early 30s who are committing VUPA offenses on average. We see that the majority of our sample are Black individuals with a slightly less than 40% white. We're making an effort to get ethnicity data and to figure out how white Hispanics affect this race, but we're dealing with some data limitations there, and we're trying to work around it. And so that was our first question. All of that information really speaks to identifying what VUPA offenses look like in the Commonwealth, who's committing them, what the grades are, and but as we discussed, only really one part of this process. And the second very meaty question here is going to be to identify how VUPA offenses are moved through the system, whether VUPA offenses or whole dockets are later withdrawn, dismissed, charge changed, what have you. And so because this is such a meaty question, we're still in the process of working through the data, but I want to really emphasize that the important part of this directive is to identify not only the end disposition for these charges, but at what point. those charges are withdrawn or changed. And for this reason, it requires us to link those AOPC files that we talked about very carefully and at each stage. So creating a pretty long chain of data. And we'll be doing this both at the charge and the docket level. And once that process is completed, we'll be identifying the relative rates of dismissals and withdrawals out of total, total dockets and total charges. We'll be looking at variation by court type. For example, do withdrawn charges happen more before bind over or after? And then looking at charge variation, differences between 6105 and 6106, for example, differences across individual characteristics, as well as differences across counties, primarily working within that county class structure. Once we've done that and kind of traced the process of court processing for VUFA offenses, we're going to link those sentenced offenses for in the AOPC to PCS data. We're going to do that because our third directive is to determine the sentence received, and we're particularly interested in the imposition of incarceration, whether that incarceration is local or state level, the length of the incarceration, and how many VUFA offenders receive primarily community-based sanctions or community sanctions in addition to incarceration. And again, we're going to be really focusing on the relative rates of incarceration, differences across charges, differences across individual, as well as differences across county and county class. Now, the fourth bucket asks us to outline the sentencing guidelines for individuals who are charged with VUFA and compare it to the sentences received. And so in doing that, we're going to focus on individuals who have a VUFA offense who filed in the court of common pleas. And we're going to be looking at the distribution of those OGS values, PRS, what individuals, what cell they fall into, what's the recommended type of sanction, what's the recommended length. And we're going to be doing this both for individual charges as well as aggregating across multiple offenses within a docket, and also considering guideline conformity. And similarly to the other questions, we're particularly interested in variation in these outcomes across charges, across individual characteristics, and across county and county class. Now we're finally getting to our third bucket, which I haven't spent much time talking about thus far, which is the recidivism of individuals who are charged with VUFA offenses. The directive was pretty particular about the type of recidivism they're looking for, and they're interested in violent offenses, and it specifically enumerated several of them. And so we are in the process, and we'll be trying to get Penn State Police records for all individuals who have these filings. But in the meantime, our strategy is going to be to partition the data to basically say, okay, of the individuals who were filed in 2015 to 2017, how many of them do we see having subsequent filings in our AOPC data? How many of them have subsequent filings overall, the time period, within a year, within 3 years? And by doing so, we're hoping to be able to have some findings earlier, just because requesting the rap sheet data is a time-consuming process, and as well as getting it into a form that we can use it and link it to this data. So this is a way of getting at that a little bit earlier, and we'll supplement that with rap sheet data as we're able to. And then finally, HR 111 also directs us to consider not only arrests, but also violations of community supervision, whether that be individuals who are sentenced to a primary sanction of probation, or individuals who are ultimately released on a term of parole after a period of incarceration. And so to do that, we're going to use our PCS resentencing data, which I think many of you may remember from our Vital Strategies project. And we're hoping to supplement that with cooperative agreements with jurisdictions who are known to have good quality electronic data for their supervision clients. And we're also going to be trying to work with Department of Corrections Parole to attain their records as well, and supplement our data in that way to give a really comprehensive picture of what supervision violations look like for this sample of individuals. All right, that's what I have. Thank you for your time.
Thank you very much, Dr. Galvin. Executive Director.
Sure, thanks. Matt, any other issues or oh, I see Chairman Johnson has his hand up.
Chairman Johnson, go ahead. If you're speaking, you're muted.
Okay, maybe that's a false alarm. So
I had my hand up. This is Todd. I don't know if there's a. You're putting that?
go. Yeah,
Todd,
go
you
ahead,
can
Rep.
Judge Marsh goes over here, man in the mouse. I'm not sure if he's putting my hand up or down, but either way, you'll wait to hear the question first. And I'm almost embarrassed to ask this, in terms of the offenders, is there, are we collecting data also about who was on parole or under supervision when they committed the VUFA offense? Is that part of the analysis?
I will do my very best to do that. Because we're using AOPC data for the bulk of our analyses, they do not currently provide supervision status as part of that. But there are certainly ways that we can go about trying to indirectly and supplement that data with their supervision status.
I guess there's one other possibility, and as Dr. Gavin said before, trying to look to the DOC and to the parole board for information that can be used in any number of studies. I think it's always easier at the state level to try to see if someone's under supervision, because we can work with the parole board and it's a sort of statewide data set that we can use to sort of check that. It's just much more difficult at the county level to try to determine if someone's under supervision at the time, just because of the lack of sort of standardized records that we could have access to. But I know in the past we've tried to do this. It's pretty difficult, but as Miranda said, she'll try to work some magic and see what happens. Great, thanks. And I think where we left off before the alarms, Representative Stevens was asking a question or making a comment, and so let me just see if there's anything remaining on that line.
Yeah, just one other quick follow-up. Was it really lengthy question based on the fire alarm and everything? But when you look at the prior record score for the offenders, will that include any type of information about the type of crimes for which they had been convicted, or just simply prior record score?
We can certainly look at that for those individuals.
I mean, even if it was just crime of violence versus not crime of violence, things like that, I think.
We can certainly, if that's something that y'all would like to see, we are certainly able to do that.
I mean, I think it would be helpful. I'm not sure if the other commission members have a thought on that, but I think it would be helpful to understand, just a little bit more granular data on the prior offenses. Not, we don't need all the nitty gritty for every retail theft or whatever, but even in broad categories, I think would be helpful. Personal injury maybe versus property versus crime of violence or something like that.
Yeah, we'll be able to do that from PCS data currently, but we also hope to get the rap sheet information from the state police, which will give us a full history of all of those previous offenses as well.
Great. All right. Thank you.
Judge, I believe Judge Tucker has his hand.
Yeah, but I
How about if I
was
just
just going
call
to
on Judge
comment that, I agree. I mean, if we're doing it, we may as well do it all, as opposed to doing it halfway. We just as soon see the depth of it, and perhaps we can do something about it, as opposed to just touching the surface of it.
Makes sense. Thanks, Judge. Let me just add one other comment. It goes back to a question the rep had regarding those under supervision. And as I said, it's sometimes difficult, and in the past it was very difficult The commission has been involved in an effort to upgrade a reporting system through JNet, where county probation and parole, adult probation and parole reports to the state, and county jails report. And there had been a problem with that system where it was basically not overwriting previous data, and so it wasn't useful because it was wrong. There's still some problems with it because it's, every county reports things a little bit differently, but that may be a source of data at the county level that we can at least look into. The commission's efforts have been sort of as a middleman. We have been providing grant funding to counties to upgrade their system so that the bug has been fixed. And most counties that asked for the funding received it and did the fix. There's a couple that are outstanding, and we haven't looked at whether the data is useful. But what I can do is make sure Dr. Galvin has that kind of information. We can pursue it and see if it's helpful. As I said, for those under state supervision, we may have an avenue with the board or with the DOC, so we can certainly investigate that. So these are difficult things, but I think if there's a source of data, we'll certainly try to take advantage of that. With that, Matt, was there anything else? Miranda, anything else to close with?
No, I think we appreciate certainly the input that we received for our analysis, and look forward to sharing preliminary results and receiving additional input as we move towards the completion of that study.
Great. Thanks to both of you. I know it's a lot of work, but I really appreciate it. The next report that we have goes back to parole guidelines. As many of you recall, we've been working for years on parole guidelines, and we really paid closer attention to it in the last couple of years, worked really closely with the parole board and the DOC. And last year, the spring of last year or summer of last year, we held public hearings, as I mentioned yesterday, including public hearings where we connected with 5 of the state correctional institutions, heard from individuals there, really useful hearings. We took that information back, and remember, it was both about parole guidelines and recommitment ranges. So recommitment ranges are those recommendations to the board to consider when someone has been revoked on state parole. And the procedure in those situations is the parole board recommits the individual for a fixed period of time. So we were providing recommended ranges for the board to consider. And then upon the conclusion of that period of time, the board could consider the person for re-parole. So it works a little bit differently at the state level and the county level, but the commission has these responsibilities for these two sort of structures. So parole guidelines, recommitment ranges. And we did some work after those public hearings to modify both of those proposals, but then we put things on hold because the Department of Corrections was looking at a new instrument to be used to assess risk and to do planning for community release. So they were using the LSIR, they were switching to the strong R, but it was being built specifically for the DOC. And it's been a great project, and Matt and Brett have been involved in the discussions with DOC, but it's a slow process. And one of the reasons we wanted to provide a presentation this morning was to sort of bring members up to date, or, for some new members, just familiarize you with what we've done and what's sort of on hold there. And then I think the big question is how do we proceed? Because we were really engaged a year ago with the board and really moving this forward. And while I continue to attend their board meetings and work with the board, it just seems to me that we're sort of in stasis right now. And I hate to see us sort of lose the energy on this. So we want you to just know where things are, and then just sort of discuss what our next steps are. Do we remain on hold, or do we try to sort of move forward using the current risk assessment information, which is what we built the instrument on, and then think about a plan for transitioning over once that new instrument's in place. So with that as background, and I hope I didn't steal any thunder. I'm sure I didn't. I'm going to turn it over to Brett to bring you up to speed on that. Thanks, Brett.
Good morning, everybody. Yeah, as Mark said, we've sort of been in a bit of a holding pattern here with the state parole guidelines. But as many of you remember, we did do a lot of work over the last 2 or 3 years, and I think had really come to a place where we'd made a lot of progress, and we had a lot of buy-in from the parole board. And we're kind of at the doorstep of adoption there. And then about a year and a half ago, we sort of hit a roadblock where we weren't quite sure if we should move forward with what we had or wait for the Department of Corrections to transition to their new risk assessment. I just want to sort of walk through the work that we have done up to this point, and just sort of refresh everyone's memory as to what our proposed guidelines look like and where we are today. So to start, Act 81 of 2008 mandated the commission to develop parole guidelines and recommitment ranges. So along with that mandate, there was a series of basically of rules we needed to follow in order to build out these guidelines. So number one, the most important factor was obviously the protection of public safety. In addition to that, the guidelines must provide for consideration of victim input. And in addition to risk, there are also several other factors that the guidelines needed to consider. Part of that was sort of looking at the conduct of inmates during their time in confinement and evaluating them on their performance during their incarceration. So that includes participation in programs, lack of misconducts, those sort of things. And finally, one of the goals of the parole guidelines is to be able to release some of these lower risk inmates and prioritize incarceration for those higher risk inmates. And finally, the sixth item here is that the guidelines must use validated risk assessment tools to identify the risk of recidivism. As I mentioned, we first received this mandate in 2008 with Act 81 of the General Assembly. And this act added several new responsibilities for the commission. But a part of that, again, was the adoption of guidelines for parole and the adoption of recommitment ranges following revocation of parole. So that was 2008. Over the next few years, the commission did a lot of exploratory research and background work, just trying to gather the data and sort of learn about the parole process. Then in 2016, the commission developed a partnership with the Robina Institute at the University of Minnesota. And we came to an agreement where the commission would provide Robina with a set of data sets that they could use to analyze parole in the state of Pennsylvania. Part of this was a part of Robina's program where they go across the 50 states and sort of analyze the parole systems in all 50 states. So as part of the Pennsylvania process that they were doing, we agreed that we would provide them with a set of data sets. And in addition to the quantitative analysis, Robina also conducted interviews with board members, parolees, inmates, just to sort of get a feel for the motivations of parole and primary factors for board members, and as well as getting a feel for how well inmates know the process, how they prepare for the process, and those type of items. So in 2017, we collected our data. We had some collaborations with, obviously with the parole board, the Department of Corrections, and the Pennsylvania State Police to collect data. We also used commission data. We combined these data sources and developed a data set with over 100,000 parole interviews that took place between 2010 and 2016. Additionally to the information on parole interviews, we also developed a data set to analyze recidivism of parolees. That was looking at all parolees from 2010 to 2013. In 2017, we provided those data sets to Rabina and they conducted their analysis and as well as their interviews. Some of the primary findings from Rabina's interviews were that the board members' primary focus obviously is on ensuring public safety, minimizing risk. But another thing that many board members mentioned was that they were also very concerned with offender rehabilitation. And they even mentioned the motivation to give offenders a second chance when they've been rehabilitated and shown that they have remorse for their actions. And it was really emphasized by the board members that one of the most important parts of the whole parole process is the face-to-face parole interview. They expressed how powerful these interviews are and really how important it was that we don't go to a set of guidelines that's strictly analytical, but that we also keep a portion of it where the face-to-face interview is meaningful. So moving into 2018, commission staff conducted parallel quantitative analysis at the same time that Rabina Institute was doing their study. One of the primary things we did was look at the parole board's current decisional instrument, which gives a numerical score to each parole candidate and then recommends to grant or refuse parole based on that score. In 2019, we held a one-day parole board retreat where commission staff went to the parole board offices and basically spent the whole day going over our findings from our quantitative analysis. But also, we got into some really good informative discussions with the parole board members about which factors that they feel are important in parole, whether or not we could move forward with the current decisional instrument that the parole board uses, or if we should develop something new. And at that meeting, I think it was agreed to by everyone that we needed to move forward with a new decisional instrument to replace the current 361. So to dig a little bit deeper into what parole board members were most interested in their decision-making, we knew that risk was the primary factor, but we also wanted to get a feel for some of the other factors that are related to offenders' personal responsibility and some of the other factors I've mentioned, like participation in programming, misconducts while in confinement. So we conducted a pretty thorough, in-depth survey of board members, along with hearing examiners who also conduct these interviews. And survey results gave us an indication of what board members wanted to include in the new parole guidelines. Number one, obviously, risk was still considered to be the most important factor, needs to be in the guidelines. Number two was that board members insisted that there needed to be a series of other factors that would be an indicator of an inmate's readiness for parole release. So some of the things related to accountability, personal responsibility, and general behavior and preparedness to be released out on parole. And then finally, the last finding from the survey was that there really are a number of findings that come out of the face-to-face interviews that the parole board members really insisted should be a part of the guidelines. We heard from many board members that, again, a decision just can't really, even a recommendation can't be made without first factoring in that face-to-face interview. So in September 2019, the commission presented our first draft of the proposed parole guidelines. I'll walk through the specifics of the guideline form in just a minute here. But the guidelines were presented for the first time in September 2019 with some slight modifications happening basically after each commission meeting and meeting several times with the parole board members. We made slight modifications along the way. And then finally, in September of last year, we were able to hold public hearings on the proposed guidelines, which included several inmates from various facilities around the state giving their thoughts and their feedback on the draft parole guidelines. Overall, the feedback from the public hearings was positive on the parole guidelines and included a positive recommendation from the chairman of the parole board. That's sort of where we are today, that we've sort of been in that holding pattern ever since those public hearings, where we decided to put a pause on the project. But now to revisit this process, I want to walk through the guidelines that we did develop and sort of what we had in mind for how those should work. So the first element of the guidelines is that risk needs to be taken into account individually. That was one of the problems with the current parole board instrument, is that it took the recidivism risk portion and combined it with other factors. And it sort of watered down or diluted the effect of the risk score. And what we found as a result of that is it wasn't as predictive of recidivism because of that. So it was important to us to keep risk as its own separate factor in the guidelines. Next, we want, as recommended by the parole board members, we wanted to use other factors that would be an indicator of an inmate's readiness or preparedness for parole release. And finally, as I mentioned, we wanted to make sure to incorporate the board members' findings after conducting the face-to-face interview. So the guideline recommendation, again, can't be made until after the interview is conducted. And finally, we wanted to allow for certain considerations or override factors for certain factors that may not be present in the typical parole case, but when they are present, they're important enough that they can swing the parole decision just with the presence of one of those factors. So an example would be victim statements. If there's a particularly strong victim statement, that can certainly override the recommendation in one direction or the other. Another overriding factor would be an out-of-state detainee. So what we came up with to sort of keep risk as its own separate thing was to come up with two scales. The first scale is the risk scale on its own, and the second would be the preparedness scale. So the idea is if someone is high risk, low preparedness, obviously that would be an unlikely parole candidate. Someone who's low risk, high preparedness would be an ideal candidate. For the risk portion of the guidelines, we decided to use the LSIR scale, which is the Department of Corrections General Recidivism Assessment. Every inmate receives an LSIR assessment upon going into confinement. It's also helpful that the LSIR is available for every inmate. That makes it a little bit easier for us to gather our data for the parole guidelines. And it's also been validated on Pennsylvania inmates. One item that we found is that there is a difference between offenders that had an instant or prior violent offense versus those that didn't. What we found is that after parole release, those that have a violent offense in their history are twice as likely to commit a future violent offense. So as a result of that, and due to the fact that the LSIR doesn't distinguish between violent recidivism versus general recidivism, we decided to generate two separate decision grids, one for non-violent offenders, one for violent offenders. As I mentioned, we developed a parole preparedness scale. This includes 11 factors that are not related to risk. They're mostly based on an inmate's conduct and indicators of personal responsibility during incarceration. Basically, what we're looking for is signs of rehabilitation and signs that someone would be successful during parole release. So combining the two categories, we come up with a decision grid. Risk categories are divided into high, medium, and low risk. And the preparedness categories, the same, are divided into low, medium, and high. So this would be the grid for a non-violent offender. And as you can see, anyone with a high preparedness would be recommended for parole. And then in the medium preparedness category, those with medium and low risk would be recommended for parole. Now we'll just walk through sort of what the guideline form would actually look like. So the idea is that this can be sort of a one-page summarization of the parole case. It won't have all of the details, but it'll have all the basics that can help you understand the case. So at the top, we have offender information, including information on the instant offense. And then moving on, we have the risk score and risk category. Next would be the preparedness score. It actually goes through factor by factor and shows how the inmate scored on each of the individual factors that go into the preparedness score. And just revisiting those preparedness factors one more time, those were divided into pre-interview factors and post-interview factors. So the pre-interview meaning that these are things you'll know ahead of time before the interview. So those consist of program completion. The inmate needed to be misconduct-free for the past year. And for each of these elements, you get a score of 0 or 1, depending on whether or not you meet the criteria. Free of assaults or criminal misconducts for the past year, free of prior probation or parole revocations, a positive recommendation from the DOC, free of alcohol or drug dependence, and the inmate must be compliant with any prescribed medications. The next portion is the actual post-interview factors. So these are the items that aren't known until the interview is conducted. But again, the board members insisted that these are very important factors when making the decision. So there are 4 of these factors. Number 1 is the inmate's expressed motivation for success. And these are as evaluated by each individual board member. Number 2 is the inmate's expressed acceptance of responsibility. Number 3 is the inmates expressed insight into their criminal behavior. Basically what that means is, does the inmate, do they have an awareness and understanding of the actions that they've taken? And more importantly, do they have a plan in place mentally of what they'll do next time if they find themselves in a similar situation to the one that got them here in the first place? And the last interview factor would be a stable release plan. So after tallying up the preparedness score, you can then move to the decision grid, find where the inmate falls on the recommendation grid, and make the parole recommendation. And then finally, at the bottom of the guideline form would be a list of those override factors that could potentially negate the recommendation for parole. And so as Mark alluded to, the LSIR is in line to be replaced by the Department of Corrections as their risk assessment. It was announced in late 2019 that the DOC would transition to the strong R risk assessment, which is more of a risk needs responsivity assessment, more of a case management type of assessment. And that process is ongoing. The latest word we received is that the process of validating that new assessment will likely continue well into 2022. So that sort of brings us to our current decision point. We can move forward with the guidelines using the LSIR as our risk assessment, which will continue to be available up until the moment when the Department of Corrections makes that switch. Or Option two, I guess, would be continue to hold on the parole guidelines and wait until we get that completed validation of the strong R risk assessment. So with those options out there, I guess I can open it up to discussion by the commission members for any insight that you might have.
Is there anybody who has any thoughts or questions?
I have one,
I-
Judge.
Okay, go ahead. Judge
Who
Marshall,
completes-
I believe.
Yeah, yes. Who completes this? The board member?
I think the idea is the majority of this would be automated. And obviously the final section that deals with the parole interview would have to be completed by the board members.
And if I could add something, as Brett said at the start, there's sort of a parallel instrument used internally by the board, the 361. So it's their decisional instrument. And our efforts throughout this process was to, try to see if we could reconcile these two so that this instrument, these guidelines would be sort of the public side of their decisional process. This would be the stuff that would be, that people could see. It would be available to the public in terms of release, just like sentencing guideline forms. But that certainly the board has access to more information and considers more information. And that would be sort of like supplement to this. And that would help to inform their decision and their process. So we were seeing these as complementary and sort of working in sync. And like I said, we had made a lot of progress. I think we were on the right track, a year or two ago. And I'm a little concerned we're losing some momentum. And I just want to make sure that we can sort of follow through with that, because I think it was a pretty good plan in terms of a really good use of the guidelines as sort of the forward-facing thing for transparency and that kind of stuff. And it worked well with what the board has to do internally.
Okay, and if I'm understanding correctly, we were pretty ready to go ahead, but then we learned there was a new risk assessment tool that was on the horizon, but that is more delayed than we anticipated. So the question is, do we want to approve this now with the current risk assessment tool, which may not be the quote unquote best tool, but with what we have and all these other steps, it seems like it's a much better assistant than nothing. So are you saying, let's go ahead with this now, and then when the risk assessment tool is changed over, we would modify things to adopt to the new risk assessment tool? Does that sound correct?
Yeah, I think that's along the lines. We do think we need to have one more public hearing on this. So we do want to make some modifications based on the last hearing, or get those out for public review before the commission would formally adopt. But with the acting secretary now on board, and with sort of an update that we received from the DOC about just the delays in the process, which are totally, not surprising, but it sort of adds to, what should we do? And what we're suggesting is, let's clean this up, let's publish it for a public hearing. And then if the commission adopts, the idea would be maybe these would be in place for a year or two. And then when there's the transition over to the strong R, when it's validated, we would rerun the analysis to swap out the instrument, and we might have to recalibrate things. And then we move with that, but at least we'd have something in place that we were working with. The other thing I should mention, Judge, is that, one of the delays from the very start of this was the concern about once we adopt something, and it's in place, then there's all kinds of reporting requirements from the board to us and other things like that. So we could almost see moving forward with these initial guidelines as almost a beta, where we're saying, let's do it based on the current instrument they're using. And while we're doing that, let's start to work out the reporting procedures, especially with our rebuilding of SGS Web. And then when we're ready to switch over to the strong R, then that's when we go like, big time, or go live. So we could see this almost as a test period or a beta application.
Okay, thank you. I think Representative Krajewski has a question. Go ahead, Representative.
Yes, thank you. I had a few questions. One was a clarifying one. So these guidelines aren't to replace the parole board's current process. It's more so to have it work in conjunction with their internal process. Is that correct?
That is correct. And just like with sentencing guidelines, these are advisory guidelines for the board. The board retains autonomy or discretion internally to use whatever system. But I think they saw through the process that having sort of a complementary system made a lot of sense to them.
Okay, so it's advisory. So like they could use this, but it's not like necessary. It's
No,
not compulsory.
they have to consider it, just like the guidelines. They have to consider it, but then they have the discretion to decide not to follow the recommendation.
Okay.
And they'd have to provide reasons. So that would be the mechanism for tracking their decisions, and collectively, not an individual member decision, but collective decisions, and for us to modify the guidelines.
And then my second question was in regards to the DOC risk assessment, and I mean possibly Secretary Little could speak more to us. I'm just curious more about that tool. I guess what the LSIR was, and then what the strong R is, and what's the difference between those two, and what are the perceived benefits of moving to the new tool?
I can start that answer. So the LSIR is basically a general recidivism risk assessment. So it doesn't do anything other than try to predict whether or not someone will commit another offense in the future. It doesn't, like I said, it doesn't tell you whether that's going to be a violent offense or non-violent or any other type of offense, but it's a general risk assessment. It's probably the most widely used risk assessment. The strong R is a little bit more in depth than that. You know, it's not necessarily more accurate. But it's a different sort of a different thing. It's looking at different types of risk, and then also looking at the needs of the offender, and maybe some areas where the offender could use some help. So it's sort of a case management system in that way. But it's one of the issues with the timing of the strong R is that it has to be validated specifically for each population. And that's the part that obviously is very time consuming.
Just a comment or two on that. One of the other strengths of the strong R is it's much better at providing information related to female offenders, where the current application is not so strong on that or isn't validated for that. And then as Brett said, the strong R is like a fourth plus generation, because a key component is the case management plan, what we call responsivity. And so the idea is that would really help to guide the decision by the board about what kind of conditions to impose and what kind of plan to have in place for parole release. So it's exactly the right move. It's a really smart move on the part of the DOC. It just takes a lot of work to get this in place.
So if I may, we have gotten to a point now where we are comfortable that the strong R properly implemented will give us a better predictive value than the LSIR that we're working now. In either case, and really with any risk instrument, it's only going to be as good as the data that you have that's feeding in. And we've identified some of the weaknesses both in the current system and some of the measures that we would need to take to strengthen that. And to that extent, to implement the strong R, we're going to commit the resources to make sure that we have as complete a criminal history as we can get, which currently, frankly, we're lacking. With that said, we're satisfied that as we look at its predictive value, the strong R should have a much better overall predictive value than the LSIR as we're using it now. It should work well for a wide range of populations. It's already been mentioned for female offenders. We spent a lot of time looking to make sure that there were not inherent biases in the strong R. We had identified some in the LSIR as we had implemented. In fact, that was one of the reasons why we were delayed, as we went through a pretty rigorous exercise in testing various assumptions, and we've worked through that. Beyond that, the other piece is the case management component, which removes a very subjective piece that we have right now. We're pretty much leaving it up to the individual agent or counselor and the like in our current system. That they're informed, don't get me wrong, by a battery of assessments, but the strong R brings all those together. And so it should significantly reduce the number of assessments that we would be relying upon and that the board would rely upon for that decision making. Now, one of the elements that's been mentioned here is time, and we are looking at a rollout in August of 2022, beginning with our intake population and working for our stock population, so we would be able to apply it across the board. Now, that's the timeline is pretty solid. Exactly which population would be applied to first, and how we'd go about doing that. We're firming up that strategy. We plan to have that laid in place and projected out probably within the next 30 to 45 days in terms of our game plan going forward. With all that said, I think the proposal that's been laid out this morning, if the parole board chair and the board is satisfied with the results at this point, I would see, personally, from my perspective, no harm in going ahead and putting, if we're approaching this as a beta version, if you will, because there are going to be changes inherently anyway. Once even with the adoption of the strong R, there's built into the process and indeed in the contracts for a validation. So once we've actually lived with it for a while, there's going to be a validation. Now, there are a couple of states that are ahead of us on this. They're beginning to go into their validation processes, but their experiences are unique to those states, just as ours would be based on our offender population. With that said, it's not going to be soup in the sense that it's all done. It's an ongoing and dynamic instrument by its very nature and design, which, by the way, is one of the advantages that it has over the LSIR. So I think there's no harm in this commission moving forward for public comment and review of the work that's been done to date. To the extent that the whole process is automated, and this is the layperson here, the information technology piece is certainly not my forte. Having the risk component built into the process has been, as has been described this morning, and just understanding that at some point we'd have to swap out the strong R for the LSIR, which frankly, the strong R, one of the other things that we'll be doing is more fully integrating it from an automation standpoint. So in fact, that the data would be more readily available for whatever purpose we would choose to employ.
Thank you. I just got one last closing question. How does the public comment period change if we just move forward with the current assessment tool now as the beta versus postponing until we do use the strong R assessment tool?
Well, I think that there would be a further delay. Here's like the timeline if we would go with sort of this beta approach is that next March during our next meeting, we could bring to the commission a revised version of both the parole guidelines and risk assessment, parole guidelines and recommitment ranges for the commission to review. And if they approve, we could then have public hearings shortly after that. And during the June meeting, the commission would be positioned to be able to approve those, adopt them, and submit them to the General Assembly. So we could have a January 1st, 2023 effective date. And that would be based on the LSIR being used because we've done all the work on that. So it's in place. If we instead said, well, let's delay until strong R is out and go like full bore, let's go for full implementation at the start, it probably adds a year to it because we'd have to recalibrate. We'd have to first look at the outcomes of the strong R use and then recalibrate the instrument. and then have public hearings and so forth. So the benefit of moving forward with sort of a beta version is that we get something in the field, the board gets to work with it, we get to work with the board and with the DOC on figuring out how to better automate all of this, take advantage of the capture system at DOC and JNet and things like that. And then when the strong R starts coming on board, we can do the analysis while we still have the beta in place and come up with a new one, and then start public hearings on that new version while we have a beta in place. So it would just take advantage of this sort of next year or so to sort of practice with the instrument and work on the automation and the data exchange part.
Thank you.
Thank you.
Thank you. Any other questions? I don't see any other hands raised.
Great. Well, hey, Brett, did you have any closing comments? That was great. Really appreciate it. All good? All right.
Yeah, I think we're good here.
Okay, great. Thank you. So, Judge, if I'll just hit on a couple more minor issues, and then I think Matt was going to talk a little bit about the Refresh website as a closer, sort of like your entertainment at the end. So you have to wait for that for a sec. But let me just mention 2 or 3 other things that are policy related. And certainly we've spent a lot of time talking about the proposed 8th edition guidelines. We'll talk more about that during our regular meeting. But just to keep in mind that linked to the sentencing guidelines are the resentencing guidelines. So we would not expect much change to the resentencing guidelines, except to sort of link them to new guidelines if we have those. So, so there's no real action on that. It's just to bring to members' attention that we sort of think of the 2 of those together. So any action we take on new sentencing guidelines, we just have to keep in mind we're going to modify the resentencing guidelines to track that. Separate from sentencing and resentencing guidelines, we've of course had work on risk assessment, and risk assessment falls into 2 categories. So we implemented the sentence risk assessment instrument. It's built into SGS Web, and it's part of the process now. And we had said that after the first year, we would evaluate what was in place and make any recommendations about changes moving forward. And so at the last meeting, we provided sort of preliminary information where we said, based on the analysis to date, what we found was really positive in terms of the modeling we did with data to come up with the distribution of risk and things like that really held up in practice. So we were really happy about how that held up. But in terms of the utilization of the information, changes in ordering PSIs or ordering additional information, that kind of stuff, it's sort of a mixed bag. It didn't look particularly great, but the problem is it happened in the middle of COVID. So courts were down, and staffing issues, all that kind of stuff. So we're going to continue to work through that. But I just wanted to point out that that it's a little bit difficult to do some good analysis, because 2020 was and the start of 2021 was a really interrupted year in terms of trying to do analysis of that. So we'll continue to work on that, but we really don't have more to report at this time. But I did want to mention or recall for members that the other risk assessment that we are involved in several years ago, right before COVID, was to identify a model pretrial domestic violence risk assessment instrument. And the commission approved ODARA, which is the Ontario Domestic Assault Instrument. And we were sort of in a holding pattern. And I think the last time we talked about this, we indicated that we sort of published the information about what our recommendation was, but we didn't take any further action. And the next step in the process would have been to contact precedent judges and to sort of look for opportunities to encourage the use of this, maybe pilot test with counties, other things like that. None of that has occurred because of COVID. And so I think last time we talked about it, we mentioned that we had some recommendations for changes to the legislation as well. And so I think the legislative members were going to, when time was appropriate, was to get together to look at the recommendations we had made a couple of years ago and sort of figure out how to pursue that, or if to pursue it. So I just call that to your attention. This is like a tickler file. I'm just reminding the legislative members that, if the time's right, that's something to look at in terms of the recommendations we made about changes to the legislation related to this pretrial instrument, and also for any action that we would take with counties. Maybe in the new year, we should be thinking about both of those things. So I think that sort of wraps up what I had on the policy things, and the remaining time, unless there's any questions or discussion, I'll turn over to Matt to wow you with the new website. All right, Matt, it's all yours.
All right, thank you, Mark. At the last, one of the meetings we've had in the last few months, we indicated that we had been in the process of having a shadow site, if you would. We had our old site still open, and then the new site was working and functional, and we were getting ready to deploy it. So we decided to dive in and just end the old site and start with the new site. But we just give a brief background of how this all started and the efforts by staff on this. So maybe around in 2017, there was a beginning of a holistic review of what was then the current website, and including some work done by our newest employee, Juwan Mitchell, who's here today with us, who, when he was an intern at the commission, looked at a number of other websites for parallel type of agencies, getting ideas of what our site should look like. And it was pretty clear that the old site was a little stale, and also we had kind of posted information with a primacy on making sure things were posted on the web, but maybe not really thinking about the user perspective and the design. So as a next step, we engaged with a visual display firm who helped us not only on our PowerPoint slides and some of our branding of materials, but put a focus on what this website might look like from a user perspective. And then staff worked really hard on thinking about how would we reorganize the content into meaningful buckets that really was user-friendly and approachable. Simultaneously, we wanted to make sure the old site was no longer in compliance with what were at the time or now accessibility standards for websites. So when we worked with the university liberal arts information technology group, who helped us immensely, the new website meets those standards. And there's all kinds of things, and I'm not an expert on font sizes, color choices, etc. So, but really we wanted to have it be from the user perspective and a way for us to not only have archival material. It's important for us to have all the information from the history and older guideline editions, but to really showcase the more recent materials and information. So you could see at the top, it's organized around several buckets of policy and administration, guidelines and statutes, research and data, education and outreach, and SGS web. As I scroll down here, you could see that we have consistent with the previous page, but a little more easier to find and read, a news and events section. And let me just see if this will work live. Clicking on these, there's a little lag here on my side. So we could see that for today's meeting, you could see under the news and event, it's organized in a way that one could then find how to register. It'll bring you directly to the Zoom link. So we have a lot of features that allow, again, for users to access the material, including our YouTube channel here, which somebody could come and click and join this meeting today. We also have introduced a commission calendar, and that commission calendar will include trainings and seminars that are being done, statewide efforts, including, I'll just click on it as an example. These meetings are posted, and again, if you were to click those links, you would find opportunities to register from the Zoom, as well as find materials that are posted related to the meetings. The third piece here, and something we alluded to yesterday, is this interactive data portal. And later, Brett will be talking about some of the unit's efforts to update this. But this is a portal where quick reports can be generated by users that leverage our PCS data. The current platform of that is driven by something called a company called SAS, their business intelligence tool. And that's been a challenge for us to update with new data, a challenge for us to create security patches with the university. So we've been working to move away from the SAS BI portal and beginning to explore use of this Microsoft Business Intelligence Power BI tool and replacing that. So the information and data that's available on that current data portal only includes information or data through 2018. So it's a little outdated, and this is frustrating for staff and for others in the challenges we've had of uploading and getting new data into this old portal. So Brett will talk about some efforts that we have to develop a dashboard type of approach, as well as a report builder that can be used to build these types of reports. And those reports are allow both general sentencing, for example, by county or by statewide, but also judge-specific reports. So it's quite a powerful tool. And anyone who ever visited the old site, this was somewhat hidden. It was on the site, but people just didn't see it. So now we've decided, because it's an important component, to have this be front and center. So if we come to the policy and administration, each tab has these drop-down windows, but as we scroll down, that same information that is in the drop-down is available in each of these, the pages when we clicked on it. One thing to note here is we also, in the design, have really showcased this right bar as an area where we could highlight specific material. This is an example here where we have our annual report prominently displayed. We'll update that when the 2020 annual report is available. And I think it demonstrates one of the principles here, which is to showcase new things. But if we clicked on this link, it would list all the previous annual reports are still available. So we're placing a primacy on the new material, but still having this archival feature of old meetings, old guidelines, old statutes, old annual reports, et cetera, old research reports, but not having just a laundry list of all these reports, but still making them available. This area, again, has information about the commission, standing committees, commission staff. It has our general governance area with enabling legislation, and showcases our MOUs with our partner agent organizations or universities, with Penn State University, Duquesne University, and Villanova University. So if I were to, as an example, come to the commission meetings, I just want to showcase the way this works as well is we've made a deliberate decision here to only include on the main page the most recent meetings. So we have our schedule, and then we would have the December 2021 meetings. If I were to click on the 2021 meeting, it opens like an accordion where all that information is available. And you'll see we have our slides, we have the recordings from the policy meetings that are YouTube videos hosted on our YouTube channel. Big thanks to Ryan and the Education and Outreach Unit for organizing and designing, and Christy also, and the Applications and Information Technology Unit for coordinating all this. This was kind of a hands-on effort by everybody, from research to education outreach, applications, and information technology, to make this web page work. You could see we have the agenda, the slides, the record of actions, recordings, the highlight material, the supplemental material for each of these meetings. And at the bottom, again, is this previous commission meetings link, and that includes the agenda, record of action, and minutes for all meetings since 1999, if you went to this archival space. So a similar type of design is if we come to this guidelines and statutes and we come to the sentencing area. Want to note two things here. One is this comprehensive review of the guidelines. The comprehensive review of the guidelines are all of the efforts that have been undertaken that are outlined in that document that Mark compiled about the history of why we're working on the 8th edition guidelines and what work has been done up to date. So we'll see the academic review panel, and underneath that is materials that were prepared for those meetings, JRI 2, et cetera. And the special policy meetings like we had yesterday are included in this area. And we could see again, any type of handouts are available. Essentially, they're not PDFs, but they're documents that can be downloaded as PDF type files and saved. And then of course, our videos that we have available. So let me just do one more in sentencing. We're working on some of the functionality here of how this page works in practice, especially this statutes. So I think this is just an area to highlight that this is an ongoing effort. So to get to these, you have to scroll down. They're at the bottom of the page. It's easy to lose them. So we're working on redesigning some of what we're realizing was not maybe the best approach. But when we come to the guidelines themselves, so if we click on the 7th edition, it works in that same accordion fashion where we could look at the 6th Amendment and we could see all of this documentation related, in this case, to the 7th edition, Amendment 6 guidelines, as well as the same kind of information for all the amendments for the 7th edition, but the earlier editions as well. So this is where we have this intersection of new material, as well as all of this archival information. Utilizing this right bar again, there's a quick link here for Guideline Assistance. This will go to a link for the Education and Outreach unit with email addresses and phone numbers for the members of Ryan's unit for anybody in the field who wants questions or needs assistance. And again, we have here the current basic matrix for the 7th edition right here readily available for users. I won't spend a lot of time on the next set of tabs, but let me just walk through a few other things. We want to have for research and data here. Again, we have our interactive data portal. We have a direct link here for requesting data and reports on the right. And Brett's reporting out later, he'll mention how we received numerous requests from academics, from newspapers, from the public, for data sets that are publicly available. We have in this area here, again, information about requesting data and reports, what our policies are, who we provide that to. And this is linking with current efforts to rethink that consistent with our data management plan that Brett, Mark, and Christy Bundra are working on that ensures security, but consistent policies of what's available, who's able to access those, who do we provide information and data to. One of the things that I like here, we have a featured publications section. The first one's a recent article that Mark, Brett Miller, and Jordan Zvankovich, who's with the commission, wrote that was published in the Federal Sentencing Reporter. So just showcasing our work and efforts, but embedded in here also is a ton of information about county contextual information that we collect, the JR2 reporting and certification of compliance. So as I noted at the beginning, working with Mark and working with some senior staff, including Diane Shoup, who recently retired, we went through and did an inventory of every document that existed on the old website. And there are hundreds and thousands of documents. And we really put a lot of effort and thought into where these documents should be placed, where they should be showcased, what should be archival. And that was a huge effort by staff and Mark as well. We talked a lot already about education and outreach. One of the nice things for this group that we've talked about in the past is the development of these educational videos, but the promotion of seminars and trainings that are going on that are provided by the unit. But we have a number of YouTube videos, short informational, 10 to 15-minute videos that people can watch about guiding principles, Amendment 5 and Amendment 6 to the 7th edition. And we've been working recently on making sure, and Ryan's unit has been very busy in this space of creating reference guides, updating the reference guides to make sure they're most recent. And they're short documents. So if I were to click on offense gravity score as an example, here's a one-pager explaining 303.3 for key stakeholders, just as reference materials. And in this space, we've developed FAQs, and we've recently updated these links to our partners, our justice-related agencies and justice-related association, and then other partners like the Council of State Governments. So I'll just end briefly on this SGS web component. We have a button here where that can be clicked, and then it'll be providing information for a help desk where users in the counties can have a way to reach out directly to commission staff in the education and outreach unit who are experts in the application, the SGS web. They alert us of problems. They tell us when things are not working or can be improved, but they also are asking about functionality and how to utilize that application. And you'll hear later about our efforts to not only improve the functionality of our help desk through some new technologies, but also, as we know, we're working on a next-gen SGS web application, and Christy will showcase and talk about our progress and our plan for moving forward for updating the application that we're using as we develop the 8th edition guidelines. And then finally here, again, just in a much more accessible space using these, I don't know what they're called. Technically, I call them accordions. We have quick guide references that are documentations that users can come. We have our reference materials and user manuals for the SGS web. So while we're getting close to having a fully functional website, we're still finding documents that should be added. We're working with the functionality. We're trying to make sure that it's as user-friendly as possible. But I would say we're 99% of the way there. And again, this started amazing to think that this was a 5 or 6 year effort to update this. And when I joined the commission in, I think 2019, I foolishly mentioned to Mark that I thought our webpage could be improved. He said, make sure that happens. And so I'm certainly not an expert in website design or technology, but it's been a really interesting learning experience. But I think as you review this page, please let us know if there's materials that you would like to see updated or training videos produced or any kind of reorganization or restructure. But I want to thank Mark for agreeing to take on this kind of big enterprise project, and then all the key staff in the units who spent hundreds of hours working on this. And then finally, as I've noted on many occasions, one of the nice things that we have through our partnership with Penn State University is this website is supported by the Liberal Arts Information Technology Group at Penn State University. About almost everything you see here was developed and posted by them, and they've spent and worked with us hundreds of hours as well, and continue to be an amazing resource for us when we make requests or changes we can't make on our side of we just don't have the capacity and the knowledge. They're doing that within 24 hours and at essentially no cost other than our MOU partnership. So they've been a great partner and have lended, they took those artwork that we were provided by our consultant and put them into practice, and also had many great design recommendations. Seeing it in an artwork and seeing it in practice are two different things. So it's been an interesting experience, but I'm really proud of the work. And I think hopefully members appreciate how clean and organized and nice the new website is, and reflecting the high quality of this commission in itself.
Hey, Matt, that was great. Thank you so much for all your work, taking the leadership on this and working with everyone, both internally and with Penn State, LAIT, to make this happen. I think we've gotten a lot of comments, positive comments on it. And I think just as a resource to allow people to find stuff a little bit more easily is great. And then as Matt said, work within each unit to produce content that's really useful and helpful, responsive to people, and make it available there. So it starts with Ryan and all the documents and content produced by Education Outreach, but Christy and Brett, the whole shebang. So and then with Jadine and Kathy using it to post meeting materials and other things to advertise meetings, it's really, it's a huge step up. And so again, thanks to Matt and to the whole team for making this happen.
And thank you, Matt and the team. And okay, so thank you. The presentations are incredibly helpful. For the presentation that Matt did, if we all go in there and play around with it, it becomes pretty intuitive. So thank you for that.